The authorization to release a will held for safekeeping at a probate court. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine scale form PC 548, scale for State Court Administrative Order PC 548. These forms are available for free. You can follow the link in our system that'll take you to the free form. And I hope that this video provides you some understanding of how to use this authorization to release a will that's currently held for safekeeping at a probate court. So first, let's understand why this form exists. As you can see, there's a statute at the bottom of each of these scale forms. In this case, it's 700.2515. It allows a person who created and signed a will, that person is called the testator, to store, first deliver and store, a will for safekeeping at a probate court in which they are a resident. So imagine there are lots of places that you can store your will. You could store your will in a lockbox, inexpensive lockbox at your house, a safe deposit box at a financial institution like a bank. You can store it in your safe papers. You can leave it maybe with a friend or with your lawyer. But there's lots of places to hold your will. There's no rule that says you have to file or deliver the will that you've created to a probate court, but it is one of the options that is available to you so that you can be assured that the will is there for safekeeping. So the will, as delivered to the probate court, gets a confidential filing, and that will that is submitted to the probate court cannot be accessed by public record during the lifetime of the individual. And of course, the individual can remove the will at any time that has been stored for safekeeping. So it is confidential, it is not public, and there needed to be a process upon which the person that has stored and delivered the will can then retrieve the will to release it when it's held for safekeeping. Now, the simplest way is to go down to the probate court and present appropriate identification and say, hey, I delivered this will for safekeeping in the probate court. I'd now like to remove the will. But there are times that the person is not present within that location anymore. And there could be times that that person is not in good health and can't travel to the probate court. So this particular statutory form, PC 548, is designed for the person to then authorize that release of the will. Otherwise, if a stranger went down, for example, to the probate court and said, I'd like to release the will during the lifetime of an individual, the court would deny them that right. Now, post-death, there are ways to get the will. By presenting a death certificate, the court will provide that will, and that will does become public record. So again, some information that is really relevant about whether you even want to store your will at the probate court, whether you want that to be available for public record. So let's work our way through the form and kind of understand how it works. As I've highlighted in the red, it is the authorization to release the will held for safekeeping. The county is in the top left corner, and the file number is in the top right corner. Now, the file number is a little quirky here because with a probate filing of a will, you don't get a traditional file number. The court does assign an identification number of the will held for safekeeping, but there's no file number per se that you may have. The will of is simply the name of the testator, the person that created the will and has asked for it to be held for safekeeping in the probate court. And then it says, I authorize the court to deliver to. Now, in this case, it could be delivered to a third party. So rather than just yourself, it could be authorized to be delivered, for example, to a lawyer or a family member. The sealed envelope containing my will and codicils. The will is the testamentary document, the last will and testament, and a codicil are these amendments that may be added to the will. And it says, if any, because there's not always codicils. That's being held for safekeeping in the, and then of course the name of the probate court upon which the will has been left for safekeeping. the signature of the testator, the address, the city and state, and then the identifying information, social security number or driver's license would be reflected there. Now there is another protected personal information form that would be utilized to safeguard any of this confidential information relating to social security number and or driver's license, which I provided in other instructional videos. And then of course the date. Below it is the oath of a witness. And the witness and notary are not the ones being receiving the will. So for example, if the will is being released to Jane Doe can't be the witness or notary in this oath of witness. It provides for the name of the witness, that they're being duly sworn. The witness in this particular case is the person witnessing the signature, and then of course that they've witnessed in the presence, the signing, and then there's a notarization. The idea here is to make certain that somebody just doesn't fill this out and present it to the court and release a will that otherwise would be asked for safekeeping, which could disrupt somebody's appropriately created estate plan. So again, this form used in a very particular context when a will has been held for safekeeping at a probate court. This is not the form to use if the will, for example, is in a safe deposit box and you're trying to gain access to a safe deposit box or a burial plot in a safe deposit box at a financial institution. There's a completely different statute and form for the accessing or the ability to view that document post-death. This is for the authorization to release a will held for safekeeping that is at the probate court under MCL 700.2515. Now, this form should not suggest in any way that we're recommending that you actually file your will that has been created or your estate plan with a county probate court. There are possibly more logical or better places to place that will, although this is one of your options within the palette of options. Again, we also strongly recommend that you work with a skilled, competent estate planning probate practitioner to create the will, because we don't want the will that you may have created to be defective in any way. And just because you have filed it for safekeeping at the probate court, the court doesn't analyze or audit the will to make certain that the will itself has been appropriately executed. So you could, in fact, store a defective will that wouldn't be able to be probated for safekeeping. So we really want to make sure that the creation of the document is correct, and then, of course, that the process of or the decision making relating to where you're going to store that will has been well thought out, because we don't want somebody to hide a will. We've had people, of course, say, I'm not exactly sure where my mom or dad put the will. They hid it for safekeeping so well that we can't actually find it, which can cause other challenges for purposes of admitting the will to probate and making sure that the wishes of the testator are carried out. At the Probate Pro, we are passionate about everything probate. If you have questions about this particular form or any probate or trust related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.